This is Palm Beach County. Good morning.
May it please the court. Jane Forza Walsh. With me is Chief Assistant Attorney for the City of West Palm Beach, Doug Yergin, my associate, Stephanie Serafin. I'd like to reserve 7 minutes for rebuttal, and I'm here on behalf of the appellants, 13 municipalities in Palm Beach County. In November of 2010, Palm Beach County voters approved a referendum to create a countywide Office of Inspector General. Conflict developed when the county sent the city's invoices to fund the program without first entering into interlocal agreements. This violates sovereign immunity and creates an unlawful tax. The will of the people will be carried out and the Office of Inspector General kept intact if this court severs the funding from the implementing ordinance. This court need look no further than this court's opinion in City of Fort Lauderdale versus Israel. The sovereign immunity analysis begins and ends with that opinion. It's a non-tort case which recognizes that the principles of sovereign immunity apply to municipalities, and it applies those principles to the municipalities and holds that there must be an express waiver.
So it seems that the intent of the voters of all the counties, or all the municipalities, is to have OIG services for their governments. And nobody seemed to balk when this referendum was being written up. So how, and I'm not sure, are the municipalities now saying, we don't really want to have an OIG covering us, or we just don't want to pay for it this way? How would
you have
we go
expressed it perfectly, Your Honor. We're not saying we don't want to have an Office of Inspector General. We're saying we don't want to pay for it this way. That's exactly what we're saying, and I hope that's what I said clearly in my opening statement. That's exactly what we're saying. The problem is not with the referendum. The problem is with what happened afterward with the implementing ordinance. The voters, when they voted for this referendum, did not know what was going to happen later with the implementing ordinance. And that became very clear when County Commissioner Santa Maria testified at trial. He said, without dispute, that when the voters voted, they were told that the public would be, this would be public funding. It would come from vendor contracts. They didn't know that this was going to be coming from the municipalities. And that didn't happen until later when the implementing ordinance came about. And when that came about, it was very, very clear that this was violating sovereign immunity. Sovereign immunity can only be waived by general law or by contract. The general law has to be general law from the Florida legislature. It's very clear we don't have that here. And so that leaves us with a contract. The trial court found that the contract was the referendum. In this case, we don't even have the county buying into the trial court's theory that the referendum is a contract. The county is taking the view that the referendum by itself is enough to constitute a waiver.
So is it your position then that the referendum was merely an authorization to enter into an interlocal?
It's our position that the referendum is not a general law, number one, and that the referendum is not, as a local law, isn't sufficient to waive sovereign immunity. And we know a referendum as a local law isn't sufficient to waive sovereign immunity based on the Florida Supreme Court's decision in Arnold versus Schumberg. That's very, very clear. And we know it also based on this court's decision in Denisi. Both of those decisions say that. So
when the voters passed a referendum authorizing funding for the OIG program, your position is that the ordinance was flawed from its inception because voters really don't have control over budgetary decisions.
Well, our position is that they could pass the referendum to authorize the Office of Inspector General. What they couldn't do was authorize the funding. And if they were trying to authorize the funding, then it was flawed in that respect. But again, please understand that the cities are not standing before you today quibbling with the authorization of the office itself. We are not. And I want to make that perfectly clear. We did the same at trial. We are not saying there should not be an Office of Inspector General. Our problem is with the funding. And the funding took place in the implementing ordinance. That's very clear. And when you look at the ballot ordinance and when you look at the ballot question, the funding per se did not take place with either of those within that document itself.
Did anybody raise that as a potential problem before it was put on the ballot?
No, Your Honor, and they wouldn't have, because the philosophy in this state, the constitutional philosophy in this state, is that the voters get to vote. And there was nothing unconstitutional about that referendum. So it would have been wrong for the cities to have not allowed that referendum to go to the voters.
I'm not saying stop it from going to the, I'm talking about going back to whoever drafted this and saying, look, we have a problem with this, the way this is worded.
No, that did
Fix
not
that.
happen. That did not happen, Your Honors. It did not. But when you look at the ballot ordinance and when you look at the ballot question, the municipalities themselves didn't realize that governmental entities was going to include, or was going to mean that the municipalities were going to be the ones funding it. Because governmental entities was defined, according to Merriman, the one who was in charge of setting up the Office of Inspector Generals included, according to him, and this is at 2898 of the record, municipalities, special taxing districts, the school board, the solid waste authority, and other entities. So it wasn't just municipalities. In fact, 4 lines above, where the words other governmental entities was used, the word municipalities appears. So clearly, when the voters voted, they didn't think that governmental entities was going to mean just the counties and municipalities. So
But you're conceding that it was understood that the municipalities would be on the hook for, at least in part, for funding.
No, I'm not conceding that, because remember, a moment ago, I said to you that County Commissioner Santa Maria testified without dispute that the voters were told before this went to ballot that the only funding would come from public funding. That was his undisputed testimony. And that's what they thought when they went to the ballot box.
Well, public funding includes municipal.
No. Vendor funding from vendor contracts. It wasn't from municipalities. That's what they were told.
Then why didn't they say why you have this word governmental entities in there?
I can't explain that, Your Honor, but I can only give you what his testimony was, and he was a county witness. That's what the evidence was that the county put on. And that's what the voters were told. So when they went to the ballot box, they believed, when they voted, that the funding was going to come from vendor contracts, not from municipalities. It wasn't until later, when the implementing ordinance was passed, that it became the law that the municipalities, along with the county, would be funding the Office of Inspector General.
Now, some of the cities did enter into contracts with the county to pay for the cost of the OIG program. Is that correct?
5 of the 38, Your Honor. That's correct. 5 of the 38. And there are 2 other governmental entities that have entered into contracts.
Right. Did the county pursue contracts with these other municipalities to provide for funding? Or do you know what took place there?
Not that I'm aware of, but if they did, they were unsuccessful. They were unsuccessful.
So it doesn't appear here that the county has argued that the referendum created a contract between the county and the municipalities, which would waive sovereign immunity in this case. But you're saying that was the finding of the trial court in this case?
The county has not argued that it created a contract. The trial court found that it created a contract. The county has argued that the referendum per se is enough, that it's the will of the people. Mm-hmm. That's the county's argument. The trial court found, analogizing this to this court's decision in Brooks, that it created a contract. That's a different argument than the county's argument.
Now, the county did cite a Massachusetts case, Bates versus Director of Office of Campaign and Political Finance, that the county says stands for the proposition that voters can enact a law that would constitute a waiver of
Yes.
sovereign immunity. How do you respond to that argument?
I have a very easy response to that. When you read the Bates case has a much different, well, the easiest response is the quote they use and the initiative and referendum provisions in Bates allow waivers by necessary implication. In Florida, we require express waivers. That's the easiest way to distinguish Bates. As I said, sovereign immunity in Florida is the rule rather than the exception. In Florida, that's the easiest way for this court to rule that this case has to go back to the trial court, that the trial court was just wrong in finding that there was not a waiver of sovereign immunity in this case.
Are there any Florida cases that deal with something really close to, I know you mentioned Israel, but that wasn't a referendum, as I recall. Here you have a referendum that says the program would be funded by all other governmental entities subject to the authority of the IG, which would include the municipalities.
The closest case I can give you, Your Honor, is the Keefe case, which is a 1933 case out of the Florida Supreme Court. And that case says that there cannot be referendums that deal with budgeting. That's the best case I can give you. I recognize it's an old case, but it is a case that says there can't be referendums dealing with budgeting. There's nothing more recent than that. There's no case that is like this case. The trial court recognized that. I think the county would agree. But that's the closest case I can give you. And if there are no other questions, I'd like to save the remainder of my time for rebuttal. Thank you.
May it please the court? My name is Helene Vizd, and together with Leonard Berger, I represent Palm Beach County, the appellee in this case. The county urges this court to affirm the trial court's 10-page, well-reasoned final judgment on appeal. The court properly concluded that the municipalities could not assert sovereign immunity as against themselves, as against the actions of their own people, and also properly concluded what was not addressed here before this court, but has been briefed extensively. This fee is a proper regulatory fee or a proper user fee, properly enacted by the county and properly enforced against the people who voted to fund the Inspector General. Let's take a look at the referendum language itself. There's some suggestion that somehow Jess Santamaria, a commissioner at the time, that his personal belief or understanding about how this ordinance would be funded trumps the clear language of the referendum, and that cannot be the case. Whether Commissioner Santamaria believed it to be the case is within his mind, not the words of the referendum. So the 2010 ballot question clearly said, shall the Palm Beach County Charter be amended to require the Board of County Commissioners to establish by ordinances applicable to Palm Beach County and all municipalities approving this amendment, a code of ethics, an independent commission on ethics funded by the county, and an independent inspector general funded by the county commission and all other governmental entities subject to the authority of the inspector general. As this court has noted through some of its questions, that plain language includes governmental entities. The municipalities are governmental entities. There's no way, and in fact, what I'm hearing now is somehow the suggestion that the voters were misled, not because they were told that the municipalities would not be paying, but because they were told that other governmental entities would be. That's simply not contained within the plain language of the referendum.
Right, so does it really matter what if you had like 5 voters on the stand and said, oh, I understood this, would that really matter?
Not at all, Your Honor. It's the plain language of the referendum that
So-
controls.
So, and you fit, it's not a general law, correct?
Correct.
Okay, so where, your argument is, it's akin to an express contract?
Actually, Your Honor, those three akin, okay, so we get into a little bit of semantics here. Those three paragraphs, 21 through 23 of the final judgment, actually contain a statement that by voting by referendum, the people were enacting a contract. And the county concedes that there is no support in case law for that type of implied by referendum contract. Akin to a contract, I wouldn't even go that far. We don't need to go that far because we have case law from other jurisdictions, persuasive, granted, not controlling, and including the United States Supreme Court, that says the people have all political power. When the people vote by referendum or initiative, that is a law. That is legislation. That's the basis for the municipalities being required to do what the people have said. They've created a law. In fact, in the Bates case and also in the case we cite from the District Court of Appeals in Texas, the courts were very clear to say a municipality in this case where a referendum has been passed and the people have said, we want you to fund a certain program or a certain Clean Elections Act, whatever it may be, the state or the municipalities cannot respond to the will of the people by saying, we have sovereign immunity. Because they are in essence asserting sovereign immunity against themselves.
But if the state has, if there's a state law that says that governmental entities waive sovereign immunity only up to $200,000 in a personal injury case, I think it is, or just in anything, you're not saying that the voters of Boca Raton can pass a law saying, we waive it up to 500,000?
In fact, no. And 768.28, the statute you're referring to, provides for a waiver of sovereign immunity limited to tort actions and to actions of local government, state government employees acting within the scope of their employment. So there are certain limitations. If a city or a county attempted to vary that general law, it would be in conflict with the general law, and it couldn't stand. The municipalities in this case have cited to no statute that we would be in conflict with, that the people would be in conflict with, by passing a referendum saying we want an independent Office of Inspector General and we want it funded by the governmental entities under that independent office, under the authority of that independent office.
But when voters elect their officials, they are reposing in their officials the discretion in terms of making budgetary considerations. Isn't that the case? And that
But
when...
not, I'm sorry.
No, go ahead. What were
But
you
not to
saying?
the exclusion of their ability to suggest what it is how it is they want those funds to be expended. That was the case, the Watchtower case that this court considered. The people have a right to say, we want funds expended on this project, we don't want funds expended on that project. It's very clear that all of the city charters and the county charters say the only area where referendum is inappropriate is if you are attempting to pass a referendum about specific budget items, not about what we believe as the people, our government should be giving to us. So this isn't, the referendum is not limited to exclude any area having to do with expenditure of funds. That's simply not the case.
Explain to me how the Brooks decision applies in this case.
Your Honor, in Brooks, I think this court said the voters of a municipality have the right to tell their municipality, the leaders of their municipality, how they want funds expended.
But did that Brooks decision hold that voters could form or repeal a contract on behalf of the city through a referendum?
No, not at all. And we're not suggesting that that needs to take place in this case for the referendum to be upheld. It doesn't. And in fact, as we say, those 3 paragraphs of the final judgment, remove them. This court can affirm the final judgment for any reason. It need not accept those 3 paragraphs in order to affirm the final judgment. Remove those paragraphs that attempt to associate the act of a referendum with a contract. There is no support for that kind of principle.
I thought you said it was a well-reasoned 10-page.
Except for those 3 paragraphs, Your Honor, we love the final judgment. The rest of the final judgment, very well reasoned, and supported by the cases in Massachusetts and in Texas, where we note other courts and the United States Supreme Court have said, when the people vote by referendum or initiative, that is legislation, that is the law. A municipality cannot attempt to assert sovereign immunity against itself. That's one of the headings of the final judgment. Moreover, at some point it suggested that the Keefe opinion, 1933, controls what should take place here. The Keefe opinion was pre-1968 Constitution, where the people were given in the first 8 words of Article 1, Section 1 of the Florida Constitution, all political power is inherent in the people. Any decision that precedes that 1968 Constitution cannot control the facts of this case and should not be applied. It suggested that the county does not need to if the referendum authority is to enter into a local law, that type of a referendum would not be appropriate. We haven't done that here. This referendum does not, the people did not vote that they want somehow to enter into a local law that is contrary to general law. Some of the questioning from the court seems to point to almost like an estoppel argument. How can the League of Cities be so intimately involved in the entire process from 2009 to 2011, when this entire referendum was being considered? Should the municipalities pay? Who should consider the final budget of the OIG? Municipalities and the League of Cities, the League of Cities is the municipalities, it's the 38 municipalities, sits at the table every step of the way. They actively participate in the drafting of these ordinances. They had representation on the finance subcommittee of the OIG drafting ordinance, intimately involved, waits until a first bill is received to then say, sovereign immunity protects us, you can't sue us, this isn't a valid regulatory fee, this isn't a valid user fee. I haven't found case law that suggests that the cities, municipalities should be stopped from coming before this court now.
Are there any
6
other
years later.
counties that they have a similar situation where it's shared by the municipalities in the county?
Not that it's shared between the municipalities and the counties. We must remember, our OIG ordinance is a result of a grand jury which issued a presentment telling the county that we should implement an Office of Inspector General. We were told to pattern that after Miami-Dade County. They do have an ordinance, but because of the unique circumstances of Miami-Dade County, the municipalities being intimately connected with the county, in that case, the county funds the OIG. There's also a portion of the funding that's passed on to vendors. And that can take place here, which is why the municipalities cannot say that the county's that the voters' referendum, the county's charter amendment, is imposing on them any budgetary restrictions in terms of where do we get this money, what the initial brief and reply brief are filled with statements. What programs will we need to cut in order to fund this? Those are discretionary decisions we need to make. In fact, the municipalities can pass this fee on to their vendors, as was at one point contemplated by the county's own ordinance. So there's no implication that there'll be a need for them to diminish funding for other programs by funding the OIG, as the people told them they wanted them to do. In terms of the Bates opinion and the opinion from the City of Canyon versus Fair, a couple of things I'd like to point out about those two opinions. In fact, those opinions provide not just that the people become the legislature, but that The people have a right to move forward on measures they deem necessary and desirable without the danger of their will being thwarted by legislative action. And that's exactly what is taking place right here by the municipalities. The people moved forward, they expressed their desire, they deemed it necessary to have an Office of Inspector General and to have it funded by the county and by the municipalities, and now their will is being attempted to be thwarted by the municipalities themselves.
So if one of, during the referendum election, if one of the municipalities or more had, their voters had said, we don't want it, how would that have worked? It just, their little entity wouldn't have received any OIG services and
Absolutely.
they wouldn't have received the bill?
Absolutely. And the whole requirement, by the way, and we've briefed this pretty extensively as well, the whole requirement that the majority of the voters within a municipality must approve a referendum in order for that referendum to apply to that municipality was brought about because of pressure by the municipalities to have another charter amendment that requires that the majority of the voters within a municipality must approve of a referendum in order for that referendum to apply in the county. So we've briefed extensively how exactly the historical background that led to the Love Pact, which is what that amendment was, requiring that a majority of the voters approve in a municipality for the referendum to apply there, and then the subsequent referendum that led to the OIG ordinance.
It seems to me that you're suggesting by your argument that the voters' referendum created an implied contract for payment for these OIG services. But in the City of Fort Lauderdale versus Israel case, we held that sovereign immunity barred the sheriff's claim against the city based on an implied contract for dispatch services in that case. So how do you respond to the appellant's argument that the Israel case is controlling here?
This case, this court need not even address contracts, implied contracts, express waiver, implied waiver. In fact, in the Pan Am case, and up until the Pan Am case where it was stated that you have to have an express waiver of sovereign immunity, in the Pan Am case, the court said, well, if you have the ability to contract and you do contract, then comes along with that comes a waiver of sovereign immunity. So we're not basing any, and the trial court, although it did in 3 paragraphs suggest that there was a contract made by referendum, we're not basing, the county is not basing the foundation of the waiver of sovereign immunity argument on anything to have to do with contracts. The people, by passing a referendum, created law. Of necessity, from that law comes the requirement that there is no waiver of sovereign immunity from suit. You cannot suggest that the people would have enacted a law that has no effect, which is in essence what you would have to say if you decide that that sovereign immunity was not waived in this case, that the people who have the ultimate political power can enact a law that will not be carried out because the municipalities don't want to fund what the people have mandated they fund.
But if voters pass a law that impermissibly interferes with the government officials' ability to make discretionary budgetary decisions, then that law is flawed.
If that law conflicts with general law, there's been no reference to general law that this law conflicts with. It has been suggested that because the municipalities must create a budget under state statute, that this referendum conflicts with that. The court very thoroughly reasoned through that argument and rejected it appropriately. The fact that a municipality must create a budget is not in conflict with the municipality must help to fund the Office of Inspector General. Those two laws are not in conflict. Black letter law, again, in order for laws to be in conflict, the doing of one must violate the other. Abiding by one law must violate the other. You can abide by a law that requires you as a municipality to create a budget without violating a law that says you municipality will help to fund the Office of Inspector General. So those two laws are not in conflict. There is no conflict here.
Are you saying then that a referendum can mandate a city put a budget item line in their budget?
No, in fact, I think that would be a point where you would go too far, Your Honor.
Well, how is this any different?
Well, because the referendum said the ordinance will be funded by the municipalities, and the ordinance itself says municipalities you fund, help to fund, in an amount equal to 1/4% of your vendor contracts. There's no requirement in the ordinance that the municipalities include that in their budget, a specific amount of money taken from general taxes, ad valorem taxes. In fact, as we've said, and as the trial court reasoned through as well, the municipalities can pass that fee along to vendors. They can build that 1/4% into contracts. The
Well,
county.
what if they don't?
Then they've made the decision that's ultimately made that the law in conflict.
If they don't do it that way, then they have to put it in a budget line item, don't they?
That's their decision. The fact of the matter is, the plain language of the law is not in conflict. If the municipalities decide to do that, they are by their own action creating conflict, and that's not what the court should examine to look for conflict. A conflict in the law has to be on the plain language of the law itself.
I mean, how is this really any different than saying, putting out a referendum that the city will buy 10 new police cars from ABC Auto and shall fund that purchase? Why is this different? I could pass the cost on through vendor contracts, but if I don't, then it winds up as a budget line item, doesn't it?
I suppose so, and if you allow it to become a budget line item, that's your action, that's your independent action. This referendum is far removed from a suggestion that the municipality must create a budget line item for the Office of Inspector General. That's not what the words of the referendum say, and that's not what the enacting ordinance says. Both of them are very clear. We, the people, want an independent Office of Inspector General to be funded by the county and all governmental entities under the authority of the Office of Inspector General. The ordinance says municipalities and counties shall contribute to the office in an amount equal to 1/4%. So I don't think you could compare a referendum that said we want the municipalities to buy this particular item and to pay for this particular item from their budget. Those two circumstances are a little bit different. The county strongly urges this court to recognize that the validity of an ordinance is presumed. The burden is on a party challenging that ordinance to establish that the ordinance is not valid and is not constitutional. As the trial court correctly held, the municipalities have failed to satisfy that burden. We urge this court to see to it that the will of the people is upheld and that the ordinance in question is found to be constitutional. Thank you.
Thank you.
The county acknowledges that there's no contract here and no general law to support a waiver of sovereign immunity. It's not up to the cities to come forward with or point to any general law. It was up to the counties to do that, and they've not done that. So they have no argument to support a waiver of sovereign immunity. The waiver has to be clear and unequivocal, and this court has to strictly construe it. They have done absolutely nothing to address the argument that the referendum is a local law, and as a local law, it is not sufficient and cannot waive sovereign immunity. And that is based on the Florida Supreme Court's decision in Arnold versus Schumberg. That is irrefutable.
Don't they have the authority via general law to create ordinances? By
They
referendum?
can be the general law to create ordinances, but ordinances are local laws.
Where does the power to make law by referendum come from?
The power to make law by referendum may come, it's an ordinance, and an ordinance is a local law. And as a local law, it is insufficient to waive sovereign immunity. And that, Your Honor, is based on the Florida Supreme Court's decision in Arnold versus Schumbert. It's irrefutable. And as such, it is insufficient to waive sovereign immunity, an argument that has gone unaddressed this morning.
Could we find, however, that sovereign immunity doesn't apply in this case because the referendum converted the city's discretionary budget decisions as to funding for the OIG program into an operational decision versus a discretionary planning decision under the cases, common carriers cases, and those other cases that distinguish discretionary planning decisions from operational decisions?
I don't know how you could do that, Your Honor, because budgeting is clearly a discretionary policy-making decision under all of those cases.
But can the voters remove that decision from the city officials and no longer make it a discretionary planning decision and make it more or less an operational one because the voters have said, you're going to fund this, and then it's just a matter of funding it?
There have not been any cases cited to this court that would allow that to happen. The Brooks case is not in that context, Your Honor, and there haven't been any cases cited either in the final judgment or in the briefs that would support that kind of analysis. And passing on to the argument that the vendors can fund the fees, you can't pass the fees on to the vendors. The city can't pass the fees on to the vendors. The undisputed testimony in that regard came from City Administrator Green, and he testified that you have to have a contract. The cities have to have a contract in order to be able to pass the fees on to their vendors. And they don't have a contract because they aren't providing the service. And the reason they're not providing the service is because the Inspector General is the one who decides whether or not there's going to even be a service provided to any city at any given moment in time. So they can't pass the fee on to their vendors because they don't even know whether or not they're going to be getting a service. So that argument just falls flat. They can't pass the fee on to their vendors. The county dictates the terms of the funding, and that's done in the implementing ordinance, which occurred after the ballot question. The county, again, has ignored that. The voters
Can I
did
follow
not
up
vote on the funding.
On that argument you just made? So if they charge their vendors a fee and they put it away for a period to use if the need arises, wouldn't that meet that goal?
They can't charge the vendors a fee, Your Honor. It would be illegal for them to do that because you can't charge the vendors a fee unless you have a contract. And they don't have the contract because they're not the ones providing the service. The county is the one providing the service. So they can't pass on the fee. That's why that can't happen.
Why can't they pass an internal law or some other ordinance of some kind saying that with all vendor contracts, a surcharge of X amount will be included to cover this particular project program?
His testimony was they can't do it because they're not the one providing the service. And the other testimony was, in order to do that, you have to look at the regulatory statute 166.221. It's our position that it's not a valid regulatory fee. The municipality has to be the one providing the service in order to do that. We're not the ones providing the service. And number one. Number two, under that statute, it says the municipality may levy. We're not the ones levying the charge. It's the county levying the charge. So once again, we cannot pass it on under that statute.
So I'm sorry, what's the practical effect then of the county's inability to get municipalities to pay for the cost of the OIG program? Will the county have to pay for the cost of oversight over the municipalities that refuse to pay, or just exclude them from the OIG program?
It will continue on as it does now, Your Honor. Is that your question? What will happen to the program?
Right.
It will continue exactly as it has now. The way it is being funded now is through the county's general fund being funded with ad valorem taxes, which is being paid for by the citizens in the municipalities and in the unincorporated areas of the county. So actually, the citizens in the municipalities are actually funding a portion of the Inspector General program as it is through their ad valorem taxes.
Just those cities that have entered into the interlocal agreements with the county?
No. All of the citizens in Palm Beach County are funding this program through their ad valorem taxes.
Anything further?
Let me just wrap it up a minute. I have 36 seconds. If this program is allowed to continue, there's nothing to stop the county from implementing other countywide programs. Other counties will follow, and this will impact the municipal budgets of not only these cities, but other municipalities throughout the state. And it will wreak havoc that will irreparably harm these municipalities throughout the state of Florida. We would ask that this final judgment be reversed and the case remanded with directions to enter judgment for the cities. Thank you, Your Honors.
Thank you.